I thought it would be helpful to put together just a brief series of videos where I can answer some questions for potential clients about personal injury cases. This week I ran into a situation that I thought would be beneficial for a lot of people, and so I'm going to share it with you. This week I was able to settle a case for one of my clients, and as a part of the settlement, the defendant in the matter had proposed that the case be settled on a confidential basis, meaning that they didn't want my client to be able to go and explain to other people or tell other people the amount of money that they were able to secure as a result of a personal injury claim. And oftentimes these confidential clauses are contained in a settlement agreement, and there are certain legal consequences that are involved with that. Not only can there be a potential breach of that confidentiality clause that could expose a client to potential liability, but there are also tax consequences involved as well. Some of you may be familiar with the case involving Dennis Rodman, former Chicago Bull slash celebrity slash reality TV star, really. And Mr. Rodman was involved in that incident where he kicked a cameraman during one of the games, and it's my understanding that that case ended up settling for a confidential amount. Well, after that case settled, the IRS came knocking on the plaintiff's door and wanted to talk to them about the tax consequences of that. And essentially what it boils down to is this: if you're going to agree to confidentiality as a part of a settlement agreement, you need to document the amount of money that you are being paid for as consideration for the confidentiality. In other words, if you have a $20,000 settlement and they're demanding, the insurance company or the defendant are demanding that the terms of that agreement or the amount of that agreement remain confidential, then you need to have in, as a part of the settlement agreement, a clause that outlines the amount that the claimant or the plaintiff is receiving as consideration for the confidentiality clause. And the reason for that is because that creates a taxable consequence for the IRS. So should the IRS come knocking on your door like it did in the incident involving Mr. Rodman, then you can explain to them or even show them by way of documentation that, yes, look, this case settled for X amount of dollars, but the consideration for the confidentiality was only Y, and only have a liability for those particular tax liabilities. And the other thing that's true about this is you can always consult with a CPA or a tax attorney that specializes in these things, but you need to be aware of it. And it's important that when you're represented with these types of cases that you have an attorney that's aware of these potential issues down the road. And so if you have any questions or concerns about this, feel free to give our office a call. We're located here in Las Vegas, Nevada, 702-522-7707. Have a great day.